Greetings, everyone. Welcome to another episode of the Crowdsourced Politics podcast. This is our second segment that's designed to be a little more timeless and be part of our relaunch efforts for our flagship podcast series. We'll release these segments weekly on our YouTube channel and across podcast streaming platforms. Each weekly segment will focus on things that are happening in the news and are unlikely to fall out of that news cycle over time. And our coverage will go a little bit more in depth than short news bites. This segment is all about bail reform.
A man with an incredibly lengthy criminal record was released without bail in New York after he smeared his own feces in the face of a victim sitting at a station waiting for a train.
Shootings in New York City are up 40% this year. Rapes in New York last week were up 125% compared to the same period last year. You know why this is happening: bail reform laws.
Here's the problem with our cash bail system. The idea is that if you have money, you can buy your freedom, and if you don't, you can't, and you sit in jail. 2/3 of people who go to jail in this country live below the poverty line.
So let's go ahead and get into it. Money bail as a practice has its roots in ancient history. Today, the practice is unique to only America and the Philippines. Our current bail law originated 15 centuries ago in Anglo-Saxon England. Unlike today, criminal justice was largely a private and often brutal affair. Any private citizen could kill an offender sentenced to outlawry. Family members were expected to avenge their murdered kin. Anyone caught in the act of committing a crime could be summarily executed. Over time, Anglo-Saxon law turned away from these blood feuds towards a system of financial compensation paid by offenders. Medieval English law gave sheriffs discretionary power to set the amounts of bail and to choose whether to jail a defendant. Following the adoption of the Magna Carta in 1215, a long series of proclamations and acts of parliament provided incremental steps to define and protect the legal rights of Englishmen as criminal defendants. By the 17th century, English citizens could point to centuries of statutory and common law, affording a qualified right to pretrial release. English colonists traveling to the New World brought their conceptions of law and justice with them. By the dawn of the Republic, money bail practices were well known to the framers as they drafted the Constitution and the Bill of Rights. Then, as now, its purpose was to ensure the appearance of an accused individual at trial. Today, each state has its own bail laws, but a state's bail law must also comply with federal bail laws, including the first 10 amendments. The 8th Amendment's bail clause was designed to ensure that bail not be set unreasonable high, which was not to say that bail must be affordable or even available to all defendants. The 6th Amendment provides that a defendant must be informed of the crime committed, which then allows him or her to demand a bail if the offense is bailable. The first Congress also included in the Judiciary Act of 1789 a provision establishing that, quote, all arrest in criminal cases, bail should be admitted except when the punishment may be death. Now, the bail's bondsman is another institution that's pretty unique to America. So in early America, legal custom had developed a strong presumption favoring pretrial release by means of a bail payment system. Once released, a shootery became, in essence, a defendant's jailer. However, the reality was that shooteries were pledged but not necessarily available if the accused didn't show up for trial. America's wide open spaces and general lack of localized law enforcement and courts meant that the accused individuals easily escaped. Some entrepreneurial spirits saw an opportunity in this. By posting a bond on a defendant's behalf in exchange for a fee, underwriters could turn a profit. So long as they exercised reasonable diligence to prevent escapes, courts either waived or refunded a substantial percentage of forfeitures. Regardless, bondsmen retained those fees. The exact origin of the modern commercial bail bond industry in the United States is difficult to pin down, but most trace its lineage to the late 19th century San Francisco. Two brothers, Peter and Thomas McDowell, realized that charging a fee and working directly with defendants was a lucrative business opportunity. The brothers founded the nation's first commercial bail bond firm from their father's saloon near San Francisco's Hall of Justice. The firms lasted only 5 decades, but it set a precedent and the commercial bail bond industry was born. Here's how the average commercial bail bond firm works. If a defendant cannot afford bail or doesn't have a family member or friend willing to do so, they instead turn to a commercial suitor. The firm posts bail in the full court-ordered amount and charges the defendant a percentage fee, usually 10%. The bondsman is responsible for the accused court appearance and is empowered to track down, detain, and return fleeing individuals, thus giving birth to bounty hunting. If the firm fails to do so, it forfeits the full amount of bail. If it is successful in delivering a defendant, the bail amount is returned and the firm retains the percentage paid by the defendant. The business model has proven successful and easily repeatable and has spread throughout the nation. Critics of this practice point out that it affords too much power to bondsmen to determine which indigent arrestees should and shouldn't be released pre-trial. Today, commercial bondsmen operate in nearly every state, although some states have outlawed the process. So what is bail reform anyways? When you hear the term bail reform, what is your initial reaction? It's a controversial topic, although much, if not most, of the controversy may be the result of misinformation in social media bubbles. And there's a lot of anecdotes out that say that bail reform leads to more crime. But the plural of anecdote isn't data, so we're going to go behind the headlines where facts live and clickbait dies. Let's start with a brief explanation of the use of bail in our court system. When a person is arrested for certain crimes, they go before a judge to be arraigned. At arraignment, the court can require what's called bail. In its simplest terms, bail is a set of pretrial restrictions that are imposed on a suspect. It's the conditional release of defendant with the promise to appear in court when required. In the United States, bail usually implies a bail bond, a deposit of money or some form of property to the court by the suspect in return for the release from pretrial detention. If the suspect does not return to court, the bail is forfeited, and the suspect may possibly be brought up on charges of the crime of failure to appear. If the suspect returns to make all the required appearances, bail is returned after the trial is concluded. Bail laws vary from state to state. While the federal government has some of the same requirements, we're going to focus purely on the states here. The theory behind the bail system is to provide suspects with the option to post bail, allowing them to remain free while they wait for their trial to commence. The purpose of bail is to incentivize suspects to return for their court dates. Failure to appear results in forfeiting the bail. The reality is that people who can afford bail remain free. Those who cannot afford it, though, go to jail, where they sit until their case is adjudicated. An important point here, before we move on, is in the US judicial system, suspects are considered innocent until proven guilty in a court of law. It follows then that people who cannot afford bail are incarcerated even though they are presumed to be innocent. The statistics and charts we're going to look at now are compiled from a 2022 report by the nonprofit, nonpartisan Prison Policy Initiative. The US doesn't have one criminal justice system. Instead, we have thousands of federal, state, local, and tribal systems. The incarceration rate is, as of 2020, more than 4.3 times what it was nearly 50 years ago. More than 2 million people are behind bars in America today, and nearly 430,000 people who are at any given moment occupying local cells awaiting trial and conviction. The rest are being held for minor offenses with sentences under a year. Bail amounts vary depending on the type and severity of crime the suspect is accused of. Practices for determining bail amounts vary widely across the country. But the bottom line is that the bail system disproportionately impacts people of color and the poor. Over 75% of those who are held in local lockups have not been convicted. They are presumed innocent. They just don't have the money to post bail. As you can see on this chart, we have the number of people that are released from jail and their amount of income that they make. People that are detained pre-trial make significantly less money than those that are not incarcerated. And this is true across demographics and sex. On August 4th, 1964, Robert F. Kennedy said of the bail system, quote, "What has been demonstrated here is that usually only one factor determines whether a defendant stays in jail before he comes to trial. That factor is not guilt or innocence. It is not the nature of the crime. It is not the character of the defendant. The factor is simply money. How much money does the defendant have? Bail reform. The overall jail population hasn't always been so heavily dominated by pretrial detainees. Increased arrest and a growing reliance on money bail over the last 3 decades have contributed to overcrowding. Today, in most of the country, when 2 people are arrested for the exact same crime, the one who can post a bond is released on a promise to show up for court. Their lives go on pretty much as the same as they were before. But for those people who were committed the same crime, who is presumed innocent just like the person who could afford bail, just 3 days of pretrial detention can have detrimental effects on an individual's employment, housing, financial stability, and family well-being. Detention impairs their access to justice as a result of a reduced ability to actively participate in planning their defense with counsel, contacting witnesses, and collecting evidence. Some low-level offenders may plead guilty, not because of their culpability, but because of their need and desire to get out of jail, particularly individuals with fragile employment, which would be lost if they miss work, or single parents who need to care for their children. For all of these reasons, bail reform began to be considered on both the federal level and in some states. Let's now look at the constitutional rights to bail provisions across the country. Washington, D.C. removed cash bail in most cases in 1992. New Mexico largely eliminated it in 2016. In 2017, Cook County, Illinois passed significant bail reform. The state of Illinois eliminated the practice in February, but the change won't go into effect until 2023. New Jersey largely removed cash bail in 2017, and Alaska largely ended its cash bail system in 2018. New York State passed legislation in 2019 on bail reform, making release before trial automatic for people accused of misdemeanors and nonviolent felonies, according to the Vera Institute of Justice. However, 3 months after the New York law went into effect, it was amended to allow judges more situations to institute cash bail. In March of 2020, the California Supreme Court ruled that defendants could not be jailed before their trials simply because they cannot afford their set bail. And during the last decade, research on practices to improve pretrial release decisions has increased dramatically. State laws authorize, require, encourage, or regulate court use of pretrial risk assessment tools, and about 24 different risk assessment tools are in use across the state. Now, the thing that's important to note here about risk assessment tools is that they all pretty much have the same thing, but there's still differences among them. In order to basically to sum that up, though, a risk assessment tool takes into account a person's past criminal history, the likelihood that a certain crime that was committed would lead to more crimes being committed in the future based on prior knowledge and history, and it put those factors into whether or not the person that is being accused of a crime should be released on their own recognizance, which means without bail. Continuing on, criminal justice reformers have supported bail reform for years. What are the real impacts of bail reform? Well, criminal justice reformers have supported bail reform for years, but opponents, including district attorneys, police departments, and the commercial bail industry, often claim that pretrial reform puts communities at risk. The Prison Policy Initiative put these claims to the test and published their findings in November of 2020. They found that whether the jurisdiction eliminated money bail for some or all charges, began using a validated risk assessment tool, introduced services to remind people of upcoming court dates, or implemented some combination of these policies, the results were the same. Releasing people pre-trial did not negatively impact public safety. In other words, crime did not increase. There's simply no clear evidence linking bail reforms, which have been in place for years in some cities, to the recent rise in violent crimes. In fact, the majority of cities that have seen increases in crimes have not eliminated cash bail whatsoever. There are 4 states, as well as 9 cities and counties, where there is existing data on public safety from before and after the adoption of pretrial reforms. All but one of these jurisdictions, New York State, saw decreases or negligible increases in crime after implementing reforms. And by negligible increases in crime, we mean statistically not significant, which means you cannot pin it on to those reforms. Let's unpack what the reforms were and what the real world impact was in just a few of these jurisdictions. In New Mexico, in 2016, voters approved a constitutional amendment prohibiting judges from imposing bail amounts that people could not afford, enabled the release of many low-risk defendants without bond, and allows a defendant to request relief from requirement to post a bond. The impact of this reform on jail population isn't yet known. However, what is known is that the statewide crime rates have actually declined since the reforms took effect in 2017. And the safety rate, or the number of people released pre-trial who are not charged with committing a new crime, which means while waiting trial did not commit another crime, increased from 74% to 83.2% after the reforms took effect. In Kentucky, they began using a validated pretrial risk assessment tool in 2013. In 2017, the state began allowing release of low-risk defendants without seeing a judge at all. And a statewide pretrial service agency is required to make a release recommendation within 24 hours. It also reminds people of upcoming court dates via automatic texts and calls. Judges have released more people on their own recognizance since 2013. The new criminal activity rate, which measures the rate at which people commit new crimes while awaiting trial, has not changed at all. In New York, a law that went into effect on January 1st of 2020 eliminated the use of cash bail and pretrial detention for most misdemeanors and many nonviolent felony cases. It also prohibited judges from considering public safety in their release decisions. On April 3rd, the bail reform was amended, scaling back some of these changes. The new law, which took effect on July 1st, expanded the list of charges for which bail can be set and gave judges more discretion in setting conditions for release. The pretrial population declined 45% from April 2019 to March of 2020. It is estimated that the April reform will result in an increase in the jail population, though it will likely be lower than if no reforms were made at all. The NYPD asserted in March of 2020 that the original bail reform measures were a significant reason for increased arrests in 6 crime categories from February of 2019 to February of 2020. But researchers from Human Rights Watch argued that the reforms had not been in place long enough to pinpoint them as the driving force behind a rise in crime. Ultimately, though, New York's short implementation period, just 3 months, and the absence of more complete data make the original reforms' impact on public safety unclear. On the county and local city level reforms, we have Washington, D.C. The district's pretrial service agency has used a risk assessment tool since the agency was created by Congress in 1967. But their reforms go much further. Judges cannot set money bail that results in someone's pretrial detention. There are limits to the amount of time people can spend in jail after their arrest, and the pretrial service agencies can connect people to employment, housing, and general social service resources. Over 90% of arrests are released without a financial bond. Public safety. In fiscal year of 2019, 87% of people were not rearrested when released pre-trial, and 99% of those people weren't rearrested for a violent crime, which means that the crimes that people did get arrested for, if they were arrested, was misdemeanor offenses and did not result in, were those that were arrested, meaning those that did end up getting arrested, did not commit violent crime and were more along the lines of either property, petty theft, etc. Now, in Philadelphia, Pennsylvania, in 2018, the district attorney's office stopped seeking money bail for some misdemeanors and nonviolent felonies, which made up the majority of all cases. 90% of people facing misdemeanor charges were released without bail. Research has found no difference in recidivism rates after the reforms. In Cook County, Illinois, as of 2017, judges must consider what people can afford when setting bail amounts. The impact of this is that pretrial population has declined by about 16%. The percentage of people released without cash bail has also doubled, and the increase was most dramatic for Black people. The number of overall crimes and violent crimes have continued to decline as well. The vast majority, 99.4%, of people who were released pre-trial between October of 2017 and December of 2018 were not charged with any new violent offenses, and 83% remained charge-free while their cases were pending. As of 2021, Illinois became the first state in the country to completely eliminate its cash bail system as well. The Prison Policy Initiative's findings appear to show that reforms to cash bail systems did not negatively impact public safety, which means crime did not increase. It is safe to say that bail reforms we just talked about are a success. And in our research for this segment, individual stories about those who have benefited from bail reform were virtually non-existent. No doubt, though, this is due to people who were released without bail, but with cases still pending, as well as the media, for whom if it bleeds, it leads, is the default position. There are anecdotal cases that did make the media, though. They're important because any violent crime is important and valid for the people in the communities that are exposed to it. In our research, we found the same stories repeated across the media, and diving into them revealed that the defendants who reoffended were out on parole or had been detained on bond that a local organization had actually paid. But there are certainly horror stories that we have to touch on. In February of 2021, Fox News reported on one such case. Christopher Michael Miller, a former corrections officer and member of the Illinois National Guard, badly beat and strangled Tanner until she was unconscious. And Miller was released the same day on an I-bond. An I-bond allows a person to leave jail without paying any money, as long as the person signs a statement saying they will return and be present in court for a hearing. On September 21st of 2019, Tanner was at home with her 9-year-old daughter, Cayman, and son Colton when the children's stepfather, Miller, broke into the back door screaming, "Are you all ready to die?" And he was supposed to be at court at that exact moment. Her daughter, who attempted to protect her younger brother, was bitten, strangled, and nearly tossed off the second floor railing. Although Tanner and her daughter were able to escape while Miller was reloading a gun, Tanner's 18-month-old son was shot 10 times in the head and killed. Fucking tragic. And then there's the story from the New York Post about the SUV that plowed through a Christmas Day parade in Waukesha, Wisconsin, killing 6 people and injuring more than 60. The driver, Daryl Brooks, has a long history of violence, with charges and convictions from restricting or obstructing an officer, domestic abuse, and rape over a 20-year criminal history. Just before the Waukesha massacre, Brooks was arrested after punching the mother of his child and running her over with his car. For that, Brooks was charged with recklessly endangering safety, bail jumping, and battery and disorderly conduct. Despite his lengthy rap sheet and no penchants for violence, he was released from jail on just $1,000, a number the Democratic Milwaukee County District Attorney has since described as inappropriately low. Another story by the New York Post reported on a man who assaulted a police officer with a stolen car on the RFK Bridge, just 3 weeks after being released without bail following his arrest on a third-degree grand larceny and third-degree criminal possession of stolen property. On the flip side of this coin, a story in The Atlantic focused on people who died in jail only because they couldn't afford to bail out. One young man recently died in a New Hampshire jail after he was unable to post simply $100. Jeffrey Pendleton, 26, was booked on March 8th on a marijuana possession charge, a misdemeanor for which a judge ordered the typical low-figure bail money. Unemployed and unable to pay, the former Burger King worker was still locked up when jail officials found him unconscious in his cell on March 13th. He was declared dead just hours later. Pendleton is one of many defendants, including Sandra Bland in Kentucky and Khalif Browder in New York, who could not even afford low bail amounts and either died in custody or committed suicide after getting out. Browder's case is especially egregious. Khalif Browder was 16 years old when he was sent to Rikers Island, an infamous detention center in New York City, on a charge of stealing a book bag. Browder spent more than 1,000 days there awaiting trial, including 700 days in solitary confinement because he refused to plead guilty to a crime he did not commit. After prosecutors finally dropped the charges in 2013, Browder earned his GED and began attending community college. But in 2015, after 3 psychiatric hospitalizations and 2 previously suicide attempts, he hung himself. These cases are not anomalies, but the result of pretrial justice system designed in a way that needlessly and tragically upends the lives of unconvicted people. It is my opinion that those who have essentially been caught red-handed for violent crimes should not even receive the option of bail. Instead, the state should bring them to trial quickly while non-violent offenses can wait. This is a resource allocation problem, not the lack of bail problem. In the case of both Miller and Brooks, both men were accused of domestic violence and both should have remained in custody pending trial, as we know from other criminal statistics that those who are engaged in domestic violence are apt to continue that cycle of violence once released from prison. While with Brooks specifically, his past history of violence should have been considered in his bail hearing. Meanwhile, Pendleton and Browder should never have been in jail in the first place. For Pendleton, even if you believe that marijuana should remain illegal, should never have been in jail pending trial, and Browder's supposed crime of backpack theft and his age should have diverted his case to community service or other forms of restitution. I personally said in a YouTube video about a week ago that Anna Kapazian was right. Bail form should be primarily about public safety and justice, not reducing the prison population, nor for equity. In my mind, justice is best served by a system that recognizes the failings of man, works to make victims whole, and protects the public. Bail does none of this. The research we've shown here makes a compelling case for bail reform and the eventual abolishment of it. Bail does not keep us safe, but can turn us into monsters. And that concludes our segment about bail reform. We hope you liked what you heard, so if you did, please smash that like button for algorithms. It really does help us out. Share us with your friends, like, comment, and subscribe, and all that jazz. And as we say at Crowdsourced Politics, keep your head up through the political storm.